for coming out tonight. My name is Johnny Sage. I'm one of the co-founders of grasspost.com. As you can see right here, our motto is we help you create your perfect product. Our focus is helping the brands in the space get connected with the contract manufacturers and find the raw material, whether the flowers or oils, to produce with. We've been doing this for a little over a year now, and over 80% of our users are more satisfied with our suppliers versus the competitors. So if you're interested in getting set up as a supplier, feel free to go to the website, or if you're looking for a product, you can check it out there, and we'll connect you with 3 to 4 different suppliers. Tonight's event is legal AMA for operators. Some of the different topics the attorneys will be speaking on include corporate structure, IP, employment, and insurance. And to start off, we have Brian Bergman from the Hemp Council. Brian?
Good evening, everybody. How are you all doing tonight? It's a great crowd, I have to say. Everybody, it's amazing to me how much this industry has changed in even the last 4 years or 5 years or so. It's really impressive to see just how many more professional-minded people have been getting involved and how much this industry has evolved over the years. And really, it's an industry that I believe, and of course many of you probably do since you're here today, is here to stay for quite a while, and it's been getting more and more legitimized as we go. There's still many more bumpy roads to get through and many different things that we're going to have to work through, but there's a lot of questions that are being involved, and of course one of the first ones is, okay, well how do I either raise money for my business, or how do I invest into it? Because, you know, to quote, or more say paraphrase Will Ferrell from the movie Zoolander, cannabis, it's what's so hot right now. So when we talk about it, you have to look at it, and I'm going to sort of skip between both sides of the coin here. As I mentioned a minute ago, you have your businesses that are trying to raise money, and then you have the people that are trying to invest into these businesses. So when you're looking for that, you have to first think about what are the different types of opportunities and businesses that you're looking to either make, create, raise money for, or invest into. You of course have your actual quote-unquote flower-touching businesses, which are the ones that actually engage in the sale, distribution, and cultivation and other ways of actually dealing with the cannabis plant. Those are the businesses that will need the licenses. They have to go through the whole different structures and procedures for getting those license applications, running through the rules for making sure that they comply with all the state regulations and your local regulations. Many other businesses may think to themselves, well, you know what, I got this great idea, or I see this industry as a very viable one, but I don't necessarily want to have to get a license and potentially run afoul of the federal government. So they may want to create an ancillary business. An ancillary business could be anything. It could be a software program that helps cannabis operators. It could be cultivation tools. It could be what I do, which is assisting with legal services or accounting services or many other different types of products. There may also be a situation where a lot of investors who are a little more risk averse may but still want the idea of getting involved and getting some good opportunity to maybe look for a real estate deal or some other holding company where they're part of a larger conglomerate of some sort that's investing in multiple different businesses, and so they're more behind the scenes but still participating. And so really, when you're going through it, you have to first decide as you're talking to it whether you are looking to raise or looking to create a new business as to what type of business you're looking to run. So once you get through that spot, the next question becomes, okay, thinking about this in the 10 minutes that I have to go over all this with you this evening, what are some of the basic things that you got to think about? You have to think about, depending on which side you're on, but it doesn't matter. If you are the investor or the one that's looking to be invested in, you are looking at a bunch of different things. You want to know what your relationship to the company is. You want to know what the type of the company is and how much it's valued for. Are you actually knowing the owners and the people that are involved with this, or are you looking for people that are closely related to you when you're doing your funding? Are you looking for certain types of liquidity? How long of a length of return are you looking for when you're talking to either investors or looking to invest? What sort of tax treatment? There's a lot of different factors, and you guys don't have to sit here and write down, but I did put a bunch of them up on the screen here for you to consider. And the idea is that you want to try and answer as many questions as possible, because no matter which side you're on, these are very important factors, and it's very important that you think through these things before you take that leap, whether it's raising or investing. So as we're going through it, and one of the things to keep in mind, if you're looking to actually invest or raise capital in an actual flower touching business, the laws under the state of California have some very important things you need to know. And it's called the MALCRSA, the Medical Adult Use Cannabis Regulation and Safety Act. It's a mouthful. With the MALCRSA, they've created certain rules and procedures that you have to follow and disclose when you want to apply for a license. And the state wants to know as much as possible. And in fact, most local cities and counties are going to be even more questioning into exactly who is involved with your business. They don't want any shadow investors. They don't want people hiding behind walls of like LLCs or other types of entities. If you are going to invest in a flower touching business or you're going to raise capital for a flower touching business, there's a lot of disclosures that you need to give. So the first question, of course, is, well, who's an owner for owning a license? Well, there's a basic definition that's there. You either are 20% or higher owner in the business, you are on a board of directors, or you're the CEO on a nonprofit, or in some way on a board for your profit as well. You might be a member of a directors for a nonprofit board, and or you might be, and this is the important one in the catch-all, controlling in the management and control of the company. And if you have any sort of decision making that has to do with the management and control, whether it's hiring and firing employees, what products to sell or purchase, where you want to be or what sort of money you want to raise, then you are involved in the control of the company. And if you are, you're going to be listed as an owner. And if you're going to be listed as an owner, you're going to have to go through a very invasive procedure and learn a lot, and they're going to want to know a lot about you. You're going to be telling both the city or county and the state where you live, what your social security number, going through complete background checks of your criminal background through a live scan. They're going to put you on a fingerprint database. You're going to be listed on the license to everybody, and anybody wants to see if you're on there. And they're going to also want to make sure that they know as much as possible about where you are and who you came from. But even if you're not an owner, you're under 20%, you're not in control, but you still want to invest, you still want to loan, you want to give, you want to invest for a rate of return, money into the business, or you just want to make sure that you're getting some sort of return for services, you're an interested party. And every single financial person involved that's providing some sort of funds to these businesses need to be disclosed. They might not need to go through the same invasive background checks, but you're going to have to be listed on the license application because the company even is going to have to explain what their bank accounts are and where they're getting all their money from. And so when they're doing that, these are things that are going to be very important to go through and know about. So no matter what, if you're going to invest or raise money in a flower touching business, there's no way to hide it, at least not legally. And that's something to very much keep in mind. So if you're going to raise money, what are you doing? You're dealing in securities. And many people don't really understand what securities are, so I thought it would be a good idea to completely and quickly go over, well, not completely, that's impossible, to quickly go over what a security is. And really there's two types. And if I'm going too fast at any point here, I'm sorry. Try to just raise your hand and go like this. It's just a matter of, I don't have time. I'm trying to give you as much as possible here. A security can be one of two things. It could be an equity security or a debt security in common terms. And an equity security is basically a situation where you're trying to give some sort of ownership interest in some way, shape, or form into a business. If you're selling any type of interest, whatever it may be, you're actually doing a security transaction. Similarly, if you're giving some form of debt via a note or otherwise, you're actually doing a debt security. Debt securities are a little different from equity securities, but they're still all securities. And so a common problem that I'm hearing and seeing for a lot of businesses is they think, well, I'm just going to go to my friends and family and go raise a couple $100,000. No big deal. I'll get little chunks here and there. They're not understanding that there's a lot of federal laws involving how to engage in the sale and solicitation of these securities. And you have to know these rules because the state has rules too. They're called blue sky laws. And you have to understand how these rules work and how you can properly solicit and raise your funds, and then whether or not you need to declare them either to the state and or federal government. So it's very important that you work with professional advisors on this to make sure that you learn and understand these rules, because if you do it wrong, you could be engaging in investor fraud without even realizing it, and that's not something you want to do. So you're going to hear from a lot of different attorneys today, and they're going to talk on a lot of different important things. And in general, I cannot stress enough to you how important it is to have good professional advice. You have to have a team, because there's no one professional advisor that can do it all. And if you're really going to do this industry, you want to make sure you're doing it in a way that you're setting yourself up safely and correctly at the start. It may feel painful financially up front, but I'm telling you, you'd rather spend the money up front to do it right than try to clean up your mess later. So some of the standard types of investments that you may want to do is you want to look for different ways to raise money. And you can get pretty creative about it. There's lots of different opportunities and ways. Some of the more common ones are you can just sell an equity and give some ownership. Sometimes if you found just the right investor, or you found the right business that you want to work with, and you've got a great new idea but you haven't really started yet, well, maybe you should just form a new entity, because there's different tax strategies at that point that come into play. So if you can just start a new business, maybe that's the way to go. But if you want to start an existing one, then you have to make sure that you follow all the rules for disclosure to get into it. Another way to do it is potentially do some sort of a convertible note or loan where you raise money for a rate of return. That's another interesting way to do it. You can also do things where you try to do some sort of secured financing, where you put up some collateral and try to get some money up front. There's other lenders out there as well that may be doing some sort of hard money loans, or other with some higher points, but a potential possibility all the same. And sometimes when you don't have the security, you don't have the income history, that could be your only option. You have to really look for the different ways to do it, but the idea being is that there are different ways to do it. You can also sit there and think, well, okay, maybe I'm one of those businesses that's going to really try to do it all myself. I'm going to vertically integrate. I'm sure many of you have heard that term being used a lot lately in this industry. And a vertical integration just means you're basically trying from one form or another to, from the minute that seed is planted in the ground, you're going to handle everything all the way through to the sales to your patients and your adult use clients. So if you're going to try and do that, maybe you want to buy your own real estate. Maybe you want to buy equipment and other things for doing this in addition to doing your licensed activity. Well, if you have some risk-averse investors, maybe some of the things that you can consider doing is trying to have them invest into other areas where you're still trying to raise capital, but where there's less risk, such as buying your building or your land, helping to invest in your build-out expenses, maybe being a part of your equipment company if you have a separate equipment company that you're putting together for leasing out all these different products to. It really becomes a question of just what and where your people are trying to look for and what you're trying to look for. And so these are very fact-specific things that become very important as you're trying to run through this. So I think I did pretty good there for 10 minutes of time. That was too short and there's so much more. But I'll answer a few questions now, and then I'll also be happy to go to the back afterwards to answer a few more quietly. So does anybody have any questions for me?
Yes, sir. Have you seen models like if somebody has a product and they don't have a license and basically going through the hoops of getting their own license, which is going to be in place, and to partner up with someone who has a license and doesn't have a product?
I think the question was, what do you do if you have a product but not a license? That's a loaded question. Right now we're still in the transition period where you're in 2018. You need to have a license to operate. And so if you are just now getting into the market, you have to run through your local license opportunities. And you have to make sure that you figure out, your first question is your location and your entity strategy as you're setting up these new businesses. You want to make sure you get your entity set up correctly and where you're operating out of, because if you don't have a brick and mortar location, in 99% of the cities that you want to operate in, there are a few that do it otherwise, you need a firm, real property location to even start. So trying to do this without a license at this stage of the game in California is, you're not going to sleep well at night. That's the best that I can say. There are still operators out there that are willing to operate in the gray areas because there are collective models that are still available, and there are still medical patients that are still collectively working together and are able to do so without a license for a short period longer. But most local jurisdictions are even requiring those collectives now to have licenses. So at this stage, you should be trying to start fresh with a licensed product if you are looking to be in this industry for a long time. Because if not, and you get popped or caught for any reason whatsoever, or something happens, in most municipalities there's a penalty. Like in LA, if you get arrested for a Prop M violation or you have something else, you could not be allowed to apply again for 5 years. And your landlord may not want to deal with you anymore because their landlord is getting $20,000 a day penalties for your unlicensed activity. So, and you are too, if they catch you. So, think long and hard before doing that at this stage. Yes, sir?
So if you were actually in that position and you wanted to fast track a license, would you recommend perhaps going like the social equity route?
Okay, the question was if you're looking to fast track a license, would you go the social equity route? That's another loaded question. I have to clear that up a little bit first off. Social equity is a program that only certain cities have adopted. LA being one of them, Oakland being another of the two more larger municipalities in California. Most cities thus far don't, but many are starting to talk about doing a social equity program. A social equity program can take many forms, and LA is taking a more socioeconomic approach, which is going to be that if you are of a certain income threshold, or under I should say, you live in a certain district that's been very adversely affected by the war on drugs and meets other certain criteria, then you may qualify for social equity. Many of those are giving up a lot of equity or space in your business to meet that. And the problem with LA is they don't have their program in place. So when you say you're trying to fast track by doing social equity, that's kind of a misnomer because the two are sort of mutually exclusive at the time. LA has not fully fleshed out its social equity program, and it's actually caused a delay in the rollout of its licensing scheme. Now, just because you are with social equity, that will probably help in LA because for retail locations moving forward, it's going to be a 2-to-1 priority basis for social equity participants, meaning for every 3 licenses issued, 2 of them must have social equity components, and if you're non-retail, it's 1-to-1. So social equity is going to be a very important facet, and it's here to stay in Los Angeles, but I can't say that that will fast track you right now because you don't even know what social equity will look like today. So if you're looking to get quicker off the ground, maybe you should be looking at other municipalities that are already licensing. Yes, sir.
I don't think this gentleman was discussing, operating any type of brand without a license. I think what he was asking was, how can the dynamic work between a brand that does not have a license, product that does not have a license, and a license holder that has a lease or owns their property and a license associated with that by partnering together? And I think that's an extremely good question because I see a vast amount of people on both sides of the spectrum where you have people that own real estate or access to leases and they have the capital to be able to apply and receive licenses, yet they don't have the background or experience or creativity to develop a brand, to be able to develop a product in the industry. And then you see the artistic people, the people who have been in the industry, know the product, and have brands, and in some cases, under medical laws, have developed a following, but they have no place to, they have nowhere to start in terms of getting licensed and stuff. So I'm seeing a lot of these 2 different groups of people starting to work together.
And you know what?
Explain how that can
Yeah,
work
absolutely.
in a legal way.
Yeah, well, that's actually sort of what my topic was about today, and just to kind of repeat for those that couldn't hear since I've got the microphone. Basically, what he was noting was, that maybe the first question I answered wasn't necessarily dealing with whether or not you were trying to operate without a license. It's that we have individuals that know how to run a business because they've been in the industry for a while, they've learned how to do the products, or they have the connections for the products because they've been basically going through it and sticking through it through the hard times. But they don't have the capital now to get licensed because licensure and buying real estate, it's expensive. I mean, to be perfectly blunt, just to even get the license application through, you're looking at 5 to 6 figures. That's just for the application. That's not including your startup, for building out your business, acquiring your property, and for putting together all the different things and getting your inventory in place. And so if you are, and it's a great point that this gentleman was making, is that you should know your strengths and know your weaknesses. And if you have a weakness, how do you bolster that? And sometimes you're right, you have people who have money or who have access to real estate and have some real world business experiences, but they don't have cannabis industry specific experience. That's where investment comes into play. You want to look to try and decide what type of the person this investor may be. Are they someone that's risk averse and doesn't want to be an owner of a cannabis company? Or are they somebody who does? And then you have to go through the different ways to try and come up with a way to solicit those funds and make a way to either A, create some sort of form of partnership or joint venture together and maybe have them invest into your company or maybe create a new company. Or maybe because they are more risk averse, you want them to go buy the building and be your landlord and you want to come to some sort of agreement with them in that way. There's a lot of different creative ways, and that was what I was saying earlier about how important it is to A, understand as the business owner what you're looking to do and what you're willing to give up, and how long you're willing to offer that for, because you have to have a good, strong understanding of your finances. Or if you're the one looking to invest in, what are your tolerances and what are you willing to do? And these are the types of things that come up and need to be discussed, and that's exactly why investing in the industry is so important, and that's why you need to understand the issues of securities and how it works.
Can we get a round of applause for
I'll go to the back for a few minutes if anybody wants to ask some questions.
Thank you for that presentation. Yeah, if anyone has questions, feel free to flow to the back. Just out of respect for the next speaker, we would like to kind of keep it quiet up here. And kind of touch on the two questions that got brought up. David Schneider would actually be talking on IP and licensing deals, and he's our next speaker. David?
Hi everybody, how you doing? So if anyone talked to me and Brian earlier, I was saying that he gets to do all the grunt work, I get the fun part of it. But it's still law, so don't expect to be too entertaining. I do, however, promise better pictures. So I always like to start with the picture of the lawyer. I think that's the most important part, but we can go to the next slide. All right, so when talking about this industry, branding is becoming a critical issue. And I'm not going to read this whole quote up here, but basically, Evan Horowitz, who was one of the co-founders of weedclub.com, talked about how brands are the next wave in cannabis. As products enter the market, the way they distinguish themselves is with unique branding and an appearance so that consumers can find your product first and stick with your product. So it becomes critical when you start a business in this industry to figure out how you're going to brand it, how you're going to protect that brand. And that comes with unique challenges. All right, so just basics. What is a trademark? The legal definition is a trademark is a word, name, symbol, or device that indicates the origin of a product, where it comes from. And so I put up some pictures here. These are things we're all familiar with. These are famous brands. These are trademarks. These are things that identify the source of the product. And it can be a wide variety of things. You can have something like the Apple logo, basic logo. The phrase, just do it, the slogan. You have the shape of a Coke bottle, actually. I think everybody recognizes that as a Coke bottle, even though there's no label on it. In this case, a fun one down here. This is a Louboutin shoe. The red sole on the bottom is a registered trademark of that company that they've actually enforced in federal court. So there are all kinds of ways that you can distinguish your product through a trademark, something that identifies it uniquely as yours. All right, so when you're in the cannabis industry, how do you go about picking a brand? I want to start with the mistakes you should not make, because these are a little more entertaining. I don't know, there were claims or litigation over every single one of these. So hashies and ganja joy, those do not go well. There was actually litigation over the Tapatio salsa and cannabis product. And actually the Gorilla Glue, there was GG Strains and Gorilla Glue. Gorilla Glue actually sued GG Strains. Obviously, that was not the logo they used. That seems a little more distant, right? You can see here hashies is clearly off of Reese's. Gorilla Glue was really a different category of product. But in this case, the glue company actually alleged that the strain of cannabis was going to undermine their brand, and the court agreed. So when picking a brand, the first thing I tell every client is stay away from the big brands. I know it seems cute, but it's not. I have lots of clients who are still selling Girl Scout cookie strain cannabis. Stop it. You are going to get sued eventually. The other thing, though, not to pick on this slide when picking a brand, actually go to the next slide and I'll talk about this. You cannot protect descriptive marks. So I had a client come to me last year who was very excited about their new brand for cannabis butter. It was Cannabutter. I told them that's not going to fly. The trademark office isn't going to protect that. It took a long time to convince them that was the case. but I actually found someone else who had already applied to register and who didn't reject it. Your brand cannot be descriptive. You cannot describe the quality of the product you're selling. You'll see that most brands that become established are distinctive. They don't necessarily have anything to do with the product. I mean, you can think of traditional things like Apple computers, Starbucks. These do not describe the product at all. I know there's a tendency, especially with new companies, to start with something that is readily identifiable, Canna whatever, OG, Kush. Consumers will recognize those, but they will recognize it for everybody's product. Nothing about that distinguishes your product. So here are some examples, though, of some of the top brands in the cannabis market today. You can see Lola is a very distinctive brand. Bloom Farms, fairly distinctive. Kiva, very distinctive, doesn't really mean anything. The other thing you're seeing a lot of these days is celebrities coming into the market and branding with their names. So the Marley Chongs and Whoopi and Maya are some perfect examples of that. I think we're going to see a lot more of this as brands start to establish themselves with their distinctive product names that will stand out on shelves to consumers. So once you've picked a brand, of course, you need to find a way to protect it. And so for traditional companies, there's a very clear route. You file for a federal trademark registration application. That gets you rights throughout the United States and gives you additional remedies if anyone uses a confusingly similar mark for a similar product. There are also state registrations available. Those are similar to the federal registrations, except the protection only applies within the state itself, not throughout the United States. In my 20-year career, I had until this year filed one state trademark registration application. It was for a dog walker who didn't even advertise on the internet. There was almost no point in doing it because it took very minimal effort to get federal protection. But for cannabis companies, that will not work. So you gain rights in a trademark by using it in commerce. You don't have to register it. There are additional benefits to registration, but in this country, the key is first use. You are the first to use your mark on your product in a geographic area. You have the rights just by using it. To get that federal registration, though, you have to have a lawful use in commerce. We all know you cannot sell cannabis products under federal law. So if you file an application to register a mark for a cannabis product with the federal U.S. Patent and Trademark Office, you can get an office action that looks a lot like this. And they raise what is called a Controlled Substances Act objection, and they will tell you because you can't lawfully use in commerce, they don't care how much you've been selling, there is zero lawful use, there is zero protection for that mark. Go ahead. So you'll still notice that there are lots of brands out there, and many of them are registered. So obviously there are ways that people are doing that. So to give a couple of examples, there are 3 different ways that I have gone about getting federal registration for brands in the cannabis industry. So the first is related services. M. Jardine, I think, is a fantastic example because they have a cannabis leaf in their logo. It is clearly a cannabis company. But what they are doing is providing services for growing operations. It's basically, their registration covers agricultural services. They don't actually sell any cannabis. Their mark does not cover any cannabis. It only covers the services they provide. The Trademark Office said that's just fine, even if there's a cannabis leaf. Same with weed maps. Obviously, it has to do with weed. Trademark Office doesn't care about that. They care what they're selling. What they're selling in their case is a service, a website that has information. So if you are in this market offering a service where you're not actually touching the plant, you have a chance of getting a trademark registration for your brand at the federal level. The second approach is what I call ancillary products. My favorite example is Kush Cakes. Everything about this example I love. So a company applied to register the mark Kush Cakes for brownies. Anybody want to guess what they sell? Hot brownies. But that's not what they told the Trademark Office. So they told the Trademark Office, we are just selling brownies. They even gave them this label that's part of their file, which shows that there is no cannabis in that product whatsoever. And so the examiner, not being an idiot, said, why do you call it Kush? And they said, we call it Kush because it's a lifestyle and because it has melatonin in it. It makes you really chill. The examiner said, okay. So they were able to get a registration. My favorite part of the story to cap it off is the month after they got their registration, there was a press release from another company saying we've now gone to market with our Kush Cakes hot brownies. So anytime you are selling a cannabis product, you may be able to sell an ancillary product that is a non-infused version of that product. So for example, I have a client who sells coconut water. They have an infused version and a non-infused version. We got a federal registration for their non-infused version. We cannot get federal protection for the infused version. The trick to this one is it can't just be trivial. You can't just print a label and say, okay, now I get registration. You have to actually put the product on the market and sell it. So most companies don't really want to do that. They just want to sell a cannabis product. The other risk to it is if you are selling both on the same website, we don't quite know how the trademark office will handle that. There was a case a couple of years ago involving a dispensary that was providing retail services, obviously selling cannabis. They applied to register their trademark. The trademark office said, you're selling cannabis that's controlled under the Controlled Substances Act, and refused the registration. And they responded, said, yes, we are selling cannabis lawfully under state law, but we also sell all these other things that are not cannabis at all. They might be related, but they're perfectly legal products, and so we want our registration for those products. And they took it all the way up to the Trademark Appellate Board that agreed with the examiner and said, even if you're selling lawful products, your primary use is for a cannabis product, you can't have a registration. And so if you do have a strategy where you roll out ancillary products, I've been counseling clients to actually set up a completely separate business, a completely separate website, and put them on that site. You then may be able to get protection. And in theory, at least, once the federal law changes and it becomes lawful, because you have protection for brownies, that's going to cover pot and infused brownies, which are really just brownies. There's a third strategy that some of my clients like. I'm not a big fan of it. I call it circling the wagons. The theory is if you can't get protection for the thing you really want it for, nobody else can either. So you get other categories that are related to it. The popular one is apparel. And you can see Canna Farms, and I don't remember what the brand is here. These are two cannabis companies that clearly sell cannabis, but what they have registrations for is apparel. And the thinking is that's never going to cover your cannabis product. Unlike the ancillary products, if the law changes, that's still not going to help you. But if there are other companies that are looking to get into the market and they go do a search and they see that someone already has it for apparel, they might decide it's not worth pursuing. So that's the third strategy. All this is great if you fit into one of these categories. What it is terrible for is if you were actually selling a cannabis product and want to protect that. So until recently, it was very difficult to do that, but now there's a new strategy. State registrations, the thing I had done one of in my entire career. In the last 4 months, I've done 25 of them. Yeah. California, as late as last year, the laws on the books said that the way that they would implement trademark laws, they would follow the federal rules. So in theory, you could not get a California registration. There was a bill pending to change that. That bill died. But nevertheless, the Secretary of State said, well, I don't really care, I'm just going to start accepting them. No rules, no real explanation, just said send them on in. And so I did. My clients started submitting applications. And what we learned is that they will provide protection for cannabis trademarks, specifically cannabis uses. And in fact, unlike the federal rules, when I submitted my first one, I used a description that was generic. It was smoking product, something like that, and they rejected it. And it came back and they said, why are you rejecting it? They said, we will accept cannabis registrations now. I said, well, your product is clearly cannabis, but the description doesn't say it's cannabis. They made me actually change it to say smoking products containing cannabis. That's a perfectly good one. So it's the exact opposite of the federal rules. You can actually get registrations in California, Oregon, Nevada, Washington, Florida maybe, I haven't tried yet. But you can go state by state and get protections. The main difference is for a state registration, you have to actually be operating in that state and actually selling the product. I've heard people say that you need to be licensed in the state. I know that's not true because I've obtained registrations for clients who don't have a license. There is a question though of whether those registrations will be enforceable if they don't get their license. So always better if you are licensed first, but I'm not sure it's really a requirement. The downside to a state registration is that it only provides protection within the state. And because cannabis businesses operate state by state, you may recall at the beginning I said rights arise from use within a geographic territory. So if you're selling a product bearing your brand in California, you get a registration, it's fantastic. You have rights throughout the state. Where you don't have rights is Nevada, Oregon, Washington, other states. So in theory, someone else could take your successful brand and replicate it in another state and start selling it. And frankly, there's no real case that has. It's kind of the Wild West. There was one lawsuit in Washington involving a company, the brand was The Clear, but it was thrown out on technical issues. So I think there is still a good argument that it's unfair competition. You're going to be able to protect your brands, but right now that's kind of an open issue. That poses an additional challenge. The way that brands are expanding is you can only operate in a state in which you're licensed. So I have clients who are licensed and operating in California, but they want to expand to Washington or Nevada or other states. They don't want to go set up operations and own a company in those states. So they do what is more traditional. They want to license out their brands into those states. But it's a bit of a chicken and egg problem. So, when Universal licenses Jurassic World to one of my clients, they have a federal registration. They've been using it nationally. It's no problem whatsoever. When my cannabis clients who are operating in California want to go license it in Nevada, they have to go to a Nevada company and say, I have rights to this mark and I'm allowing you to use it here, and if anyone challenges you, I'll defend you and pay for it. But because their rights are limited to the state, it's a dangerous proposition. You don't know that you have rights in that other state. You need to find a partner who you can trust, who is not going to sue you over it, who's not going to steal your brand from you. You basically have to write an agreement that says their use is to your benefit, and that's how you establish rights in the state. It's a little unclear so far, I think, how the states are going to deal with the trademark protection in that case. I've been fighting with the California regulators recently. I submitted an application for a Nevada company that was licensing to a California company. They didn't want to accept it. I think they will, and I think that will resolve itself, but that's sort of an ongoing fight. There are additional challenges when we take that approach because it's a little unclear who counts as an owner when you are licensing product. You would think it's a fairly normal situation. You give your brand to another company, they sell a product bearing the brand, they pay you a royalty, everybody's happy. In the state of Washington, though, their statutes and regulations define an owner as anyone who receives a percentage of the profits. Well, a royalty is a percentage of the gross revenues. You're getting a piece of the profits. So under Washington law right now, if you are licensing your brand to someone in the state, you are an owner. You have to be disclosed on the application. You have to qualify to be on that application. If you don't, you could actually blow their application in the state. California does not have that in their requirement. It's a little unclear whether or not they're going to read it into it or not. I'm hoping that they will clarify and make it evident to everybody that is not, that just having a royalty is not ownership. But right now, that's sort of an open question. There are inventive ways you can do agreements to get around this. None are that satisfying. I have seen companies that are selling packaging, so they don't get a royalty, they just get the packaging sales, and the licensee has to estimate what their sales are going to be every month, so that's how they get their revenues. I have seen people do a flat fee every month that gets adjusted once a year, something like that. It's not great because you don't know how much you're going to sell. You could be well under or well over, but I think the risk of losing your license is not worth doing it anyway. All right, so are there any questions? Anyone got any good brands?
Talk a little bit about product insurance.
Product insurance.
Yeah.
That's the last one.
I'll let the insurance person talk about it.
And for that strategy that you spoke of, circling the wagon, if a brand is using, if a company is using or trademark the brand as an apparel, and it becomes legal to actually trademark a cannabis product, would that be like a race to the courthouse scenario for someone to come and say, well then, you know what, I'm taking this brand and I'm going to use it for its actual intended purpose?
So the question was, if someone uses the circling the wagon strategy and is registered for apparel and then cannabis becomes legal, is it basically a race to the trademark office to try and get registration? The answer is no, not really. So first of all, that apparel registration provides no protection. It's almost meaningless in that situation. What does matter though is who was the first to use the mark in common. So even if you get a subsequent registration, if someone used it before you, they have superior rights. To give you an example, so I have a friend who owns a jewelry store here in Los Angeles. Just by coincidence, another company opened a jewelry store in San Francisco with the exact same name. So my friend's company operated just in Los Angeles, that other company was expanding throughout the country. My friend opened first, so he didn't have a registration, the other company did. That company sued him here for infringement, but he won. And he won because, of course, he used it first in LA, and he had rights to that LA area. So that other company could use it in the entire country except West LA, and he could use it in West LA. Cannabis will be similar, but it gets a little bit confusing. People fighting over where they used it, where their rights extend to, whether or not the brands are confusingly similar. I think it'll be a little bit of a mess until things start to shake out.
Yeah, is that going to depend on like the distribution network of the product?
It depends a little bit on distribution network, a little bit on where they're advertising, a lot on state law, because until that point, they'll be geographically restricted. So it is really entirely possible we could have two companies with the same name operating in different states and both having rights. And unfortunately, until they change federal law, that's not going to change.
I would assume, based on everything you've said, that if it's a CBD product with 0 THC, that it still falls, I mean, as part of the cannabis plant, it still falls under everything that you said, right?
Yeah, so the question was, if it's a CBD product, does all this still apply? The answer is yes, mostly. It's a bit of a gray area with CBD. The DEA still classifies CBD as a controlled substance, is theoretically subject to all the same laws. I know from experience, I have tried applying to register brands for CBD products with the trademark office. Most of what I've done is foods or supplements, because that's mostly what people put it in. And in each of those cases, they rejected it, not because it's a controlled substance, but because the FDA has not approved it for use in foods or supplements. I'm not entirely sure what would happen with topicals, but I think it would be the same result. I think they still wouldn't allow it, but it's possible. And that may be changing.
So originally, next up we have Ann Kelson. She would be speaking on employment law and labor regulations. Can we get a round of applause?
Okay, I brought my notes up just in case because I had to radically shorten my presentation. But starting organically, I'm actually an employment lawyer. I don't do labor law. Labor law is a subsection of an employment law practice, and most people who are employment lawyers don't practice labor law. Okay, so that's just a starting point because it gets used interchangeably all the time. But as most of you know, if you have a cannabis company that you're applying for a license under the state rules, if you have 20 or more employees, you need to enter into a labor peace agreement. And I'm just bringing this up front because I routinely have to explain to clients and potential clients that when you're in a situation like that, you don't want a normal employment lawyer, you want a management side labor lawyer that's used to interfacing with unions and negotiating and taking care of that aspect of one of the requirements for your license. But going back to the meteor stuff, the Tribune earlier this year estimated that over 100,000 people are going to be employed in California in the cannabis sector. It's the fastest growing sector in the country, one of the fastest growing industries in our state and in the country now, with more states moving for licensure programs. But you know, in real terms, this is kind of easier for people when they're from Northern California. If you imagine the population of the city of Oakland, which is a little over 400,000, about a quarter of the population of Oakland, that size, is going to be employed in the cannabis sector. Next slide. And the starting point for operators and those who are thinking about becoming operators and setting up your companies is that your employees are, people often say, your greatest asset and also your greatest liability, and especially in California. This is not an easy state to understand the different laws that apply, whether it comes to disability discrimination, sick pay, and what your obligations are for a variety of other things, including pay stubs and how you pay your employees every month and the benefits that you provide them. Now, in cannabis, when you're looking at some of the emergency regulations I'm going to be talking about really quickly, it's very clear that your obligations and your liabilities don't just stop with employees, but also third-party vendors and how your employees are interacting with those third-party vendors and vice versa. You can get sued for sexual harassment, or you can get sued because one of your employees sexually harasses a vendor or some other third party that's coming onto your premises, and vice versa. You may have liabilities if you knowingly observe or have some other form of notice that someone that you're contracting with on a regular basis is, engaged in some kind of unlawful misconduct. But more important than anything else, as everyone else has covered up to me right now, the cost of getting a license, of even applying and then actually obtaining one on a local level and on a state level is incredibly expensive. So you don't want to jeopardize that license that you fought so hard and had to hire the lawyers and consultants and taken, all sorts of different, investments and loans in order to get that online. So some of the things I'm going to say following this next slide relate to how you can actually avoid some liability that's specific to cannabis. So when I was looking through the emergency regulations, first or second go round, one of the things that popped up for me, and I'm sure many of you are familiar with, is just the obligations that any employer, not cannabis related, but just any employer in the state has to their employees with respect to rest breaks and meal breaks. And that gets even more complicated when you have employees that are on the road that are undertaking deliveries, or that are distribution employees that are going up and down the state and have very valuable amounts of cannabis. And the emergency regulations are clear that you can't deviate if you're a delivery service driver from a route. In fact, I've actually seen local ordinances that specify that you go from retail or your non-storefront delivery area to the designated delivery spot, to the next one, and have even written them in such a way that doesn't accommodate for breaks. Here we can see the emergency regulations do say necessary rest or fuel. Nonetheless, when you actually start thinking about what this looks like on the ground, you need to give your hourly employees a meal break for every 5 hours of work they've performed. When, and this isn't in the slides because I've tried to keep it really slide-like, but when and how that meal break is provided is really important, because it can mean a difference of millions of dollars sometimes on a class action basis. The meal break should come sometime near the middle of the shift, the case law says, but it does need to happen before the 6th hour of work. And you're also going to have to be accommodating rest breaks as well. So when you've got something else going on besides just being in a retail storefront or a manufacturing facility and you're actually on the road, that becomes a lot harder. And you also need to think about things like, well, what would I do if, for example, my delivery service driver has to take a 30-minute uninterrupted meal break, which is what the case law and the regs require of you in California, but the actual goods are still in the vehicle and they're unattended. So these are some questions that you need to start thinking about when you're coming up with your SOPs, and just thinking about how it's going to be workable for you to both comply with California law and also have safe practices when you have moving product in the state. Next slide. Brinker is a famous class action lawsuit that went all the way to the California Supreme Court. It was a case that was discussed for quite a long time. I think it took the California Supreme Court a year and a half or more to decide it. Came out in 2012, and it was focused on meal breaks and rest breaks, and really what was the obligation of the employer in providing those. And there were two schools of thought, of course. On the employer side, you can't force your employees necessarily to take a meal break or a rest break, but you need to permit them to. And you need to be able to provide an opportunity for a meal period and a rest period that is uninterrupted. That was something that was also interpreted even more in a following case. And like I said before, the meal break needs to come in the middle of the work period as practicable. And I'm skipping over, I'm trying to condense this really quickly, but for rest periods, you need to provide a rest period to all of your hourly employees for every 4 hours worked, or major fraction thereof. And there have been cases, including these, that interpret that as meaning 3.5 hours and above. There's a lot of, it's a wide spectrum in terms of when you need to time that rest break, and it needs to be a net 10 minutes. It needs to be a full 10 minutes, otherwise you're going to be entitled, your employee is entitled to an hour of pay to make up for the break that they were not actually fully provided. Next slide. Okay, so Augustus, this is the case I want to focus on because I think it's very relevant to cannabis operators of all license types. This case was a case down here in Southern California. Well, actually, no, I think it was statewide. One of my previous law firms covered it. It got a lot of press. Also went to the California Supreme Court, and in the lower court, The judge decided, this is a very interesting thing, this doesn't normally happen in litigation, on summary judgment, before they even went to trial. The judge found that the security guard company was liable for, I believe, $90 million, just for rest breaks. And it wasn't because the security guard company wasn't providing rest breaks, it was that they were actually asking their security guards to carry walkie-talkies. And sometimes, occasionally, when there was an emergency, respond. But the problem is that the way that the California Supreme Court interpreted it and looked through all these wage orders and the whole history of rest breaks and the labor code and the different opinion letters interpreting it, when you require an employee to hold a phone or to even use their own phone or to use some kind of device to communicate with other employees, and we know that happens in cultivation, we know it happens in manufacturing, we know it happens in retail for sure, you're not actually letting that employee completely be duty-free. In reality, maybe you're not calling them, but if they actually have the device with them, the California Supreme Court says that's an interrupted meal break that would afford an employee an hour of pay, just for that 10 minutes. So best practices, if you're developing your SOPs now or you're thinking ahead to the future, make sure that you tell your employees to turn their phones off or their pagers or anything else, put it in your handbook, and also have a specific walkie-talkie pager policy. And you may even ask them to just sign off before they go on their break if there's a company-provided device. But this is something that I anticipate could result in very steep violations on a class-wide basis or on a PAGA-wide basis, which is a representative kind of non-class action that can be brought in California. Next slide. Oh, okay. I didn't realize I included all these ones from this case. So Augustus is important too because the court was focused on this idea that, in holding the pager or the walkie-talkie, even if no one's getting called, that the employee is still really at work, that they're not fully relieved, and because of that, you need to pay them for that time because otherwise they would be relieved for those 10 minutes. Next slide. And then, okay, I skipped over a bunch of other things I want to cover again, just because I had to cut slides. I think I have a little bit of time, right? Yeah. Okay, so labor peace agreements. I think I mentioned those up front. Those are something that you either have to attach as part of your annual application, or if you haven't entered into one, you have to provide a notarized statement, like an affidavit, that you will enter into one. And whether you provide the notarized statement or whether you actually enter into a labor peace agreement really is dependent on whether you're approached by a union and a variety of other things. I can answer questions about that. I want to make sure people know that. Also, if there are any manufacturers in the room, there is a specific section of the emergency regs that states that you have to provide about 6 different kinds of training for your employees when they're a new hire within the first 30 days. I believe it's security, safety, trying to remember a few of the other ones, but it's something that you have to keep 7 years of records for. That's another thing. All cannabis operators are going to have to keep 7 years of records, including personnel records. And in the normal non-cannabis sphere, it's usually about 2. And there are some privacy considerations you need to think about as well, because that's valuable proprietary information, protected information as it relates to your employees, and you have an obligation to keep that under lockdown, so that it's not something that somehow gets disseminated to a third party or, God forbid, something else. And then I'm just going to focus on this because I thought it was really interesting that the emergency regulations even had specific statute or specific regulations on sexual misconduct. But when you look at them, because normally in the non-cannabis context, there's case law that interprets what would be harassing behavior, what would be considered a hostile work environment. You don't normally have a regulation that just lays out specific things that you can't do. But I believe personally that this section, and there's one other section on events, was created because of a particular controversy that arose about 2 years ago in Las Vegas at MJ BizCon. There was a well-known edibles company that had an after party with a couple other companies, and I'm not sure who was involved in the planning of it, but there was a woman who was laid out on a table with a bikini and a bunch of cured meats. So people came up and served themselves, picking off the meat, whatever. It was pretty offensive, And it was dubbed Meatgate, rightfully so. I don't have any pictures of it in my slide because it, at least for me, I think it was in poor taste. You know, I wouldn't ever, like, if when my clients came to me and said, we're thinking about doing this, I'd be like, absolutely not. And now there's an emergency regulation for it. And the reason why I'm bringing this up is because, you know, we're here in the age of Harvey Weinstein and Bill Cosby, and I've worked on very high profile cases like those cases. And I think it's a little bit sad that our industry and, you know, needs to have a regulation that is this graphic, but just to look at it, you know, you can't employ a person or use any person, so that would be the woman who was laid out in the bikini, for the sale or service of cannabis goods upon a licensed premises. Oh yes, this isn't the special event one, this is the licensed premises. And there's all sorts of specific language about, you know, what you're allowed to wear, what you can't simulate. I mean, it's, so just govern yourself accordingly. Know that the Bureau is already on high alert about any kind of sexual impropriety as it relates to, you know, retail operations. And then if you go to the next slide, there's a whole other one on entertainers and conduct. I believe this was more for like special events or the kind of event that I was describing. They can't, no licensee shall permit any person. That means, I think, your guests, other vendors, and of course maybe there's someone that's been hired, you know, to do all sorts of things here. You can read for yourself. I mean, really? Like, so, anyways, you know, there's a lot of really important basic things that you need to do when you start your operations. You need to make sure that your page stubs comply with California law. You need to make sure that you have a handbook. You need to make sure that you have meal break policies and rest break policies, because we know those things carry hefty penalties if they're violations. You need to have training that you provide employees up front. Think about specific things for your own operations, like the walkie-talkie policy, recommend you adopting. And there's loads more that I could talk about, but this is just kind of a preview for what I see coming, what could be problematic, and also what the Bureau is looking at, and I'm happy to talk with you further after, but let me just ask, are there any questions right now about any of what I just spoke at you about at mile a minute? Yes?
Can you speak a little bit about 1099 employees?
Yes. So I have not read the Dynamex case, which is the independent contractor misclassification case that just came down from the California Supreme Court last week. I wish I could speak exactly to that point, but I would say there's a reason why I didn't even attempt to cover it. And the whole consideration of who an independent contractor is, or whether or not someone could be designated as an independent contractor, has always been a very fact-intensive, factor-specific endeavor. I think it's gotten a little bit more simple, which is scary. I don't want to talk too much about that case, but I can say this. There has been a whole, like, it's not even a fraction. There's a large area of this industry or sub-industries where people have been subject to misclassification. We all know that people have had independent contractors doing everything from trim to lots of other things that are definitely not, you know, independent contractor work. And I do think that it is something that, you know, both the Department of Labor on a federal level and also, you know, on the state level has become a big issue for people. But I don't want to address the Dynamex case because there's a specific test that's been laid out there and I want to get more familiar with it myself. But I can tell you that the best news that I ever get from a new client is when they tell me, oh, you know, we did have people that were independent contractors last year, the year before, but, you know, we've made them W-2, you know, we've had them go through everything and they're not 1099 anymore, and, you know, they're hourly employees and, you know, the like. So it is a big problem. I would definitely need more than 10 minutes to go through my thoughts on that. But I do think that, you know, when you're looking at the kinds of services that you might need to engage as a company, if it is the kind of service that your company is actually involved in, that would be one of the starting points. You know, if we were just talking amongst ourselves, what does it mean for lawyers who are of counsel at a law firm? You know, what, is that really even under this test appropriate? You know, I mean, we're going to see the landscape change radically, and definitely on both the federal and the state level, there's much more scrutiny about whether or not the person that you claim is an independent contractor truly is one. So I'll leave it at that. Yes?
I have two quick ones.
Sure.
The walkie-talkie cell phone scenario, is that only if it's employer provided? If
if they use their own personal cell phone for
No, and that actually raises a really good question, another sub-question, maybe you weren't anticipating, or issue. They are supposed to be uninterrupted on their break. So it doesn't matter whether it's their cell phone or a phone that you provided them or a walkie-talkie you provided them, they need to put it down and not use it and have it be an official policy. Second issue is that many of the things that California employers may require of their employees are things that could be subject to reimbursements. And there are people that will initiate class actions for things like cell phones. You know, in California now, if you ask your employee to use their cell phone as part of the work that they perform, you're going to need to come up with some kind of configuration where you're paying maybe not the whole cell phone bill, but a portion of it, and that is based on the estimation of how much they use their cell phone for their work, and also an official company policy that you need to have in writing, that you need to have the employees be familiar with in their handbook, and also something that you're paying out on a regular basis. Like the last law firm that I worked at before I started my own practice, and also joined McAllister Garfield, they would pay all their lawyers $20 every month because they knew that we were using our cell phones as part of our work, and they were complying with California law and foresaw that that could be an issue. Does that answer your question?
yes.
Any other? Go ahead.
Yeah, it's like 5 stems from that, but I'll try to keep it short.
Okay.
I almost feel like you're taking away some of their off-time freedom by, because everyone uses their phone whenever they're not working.
This is non-negotiable, like California Supreme Court precedent, and it's something that took. I mean, even the Dynamax case, I started looking at it just now, and it's 85 pages long. I assure you, like Gus's case is that long and more. And this isn't something where it's like we could argue our way around it. The California Supreme Court has said this is what every employer has to do for their hourly employees. So just issue spotting wise, I know a lot of you use pagers, cell phones, walkie-talkies, especially for cultivation. I'm assuming, like in retail I see it all the time as well. So think about it, because it's not something that the industry is prepared for. And the Augustus case that came down, I guess it was a year and a half ago, that it's something that all employment lawyers that represent companies were furious about. And in between the trial court in that case and the Supreme Court, there was an appellate court that ruled completely the opposite way. So, I get your frustration, especially because like within Augustus itself, the security guards, they weren't even answering their phones most of the time. It was just the fact that they had to carry something with them that could bring the possibility that they might have to report to work that was enough for the California Supreme Court to say, you can't do that. Or you owe someone a whole hour's pay for that policy for every single day. So.
Can I get a round of applause?
Thank you for that great presentation. Last, we have Jason Horst, who will be speaking on good old insurance. Can we get a round of applause for Jason?
Thank you very much. Yes, they told you were going to have to listen to attorneys talk for an hour, and we're now over that. But they're going to really spice things up with insurance coverage. But since I'm not seeing my kids tonight, I will say to them what or to you what I would say to them: you will eat your vegetables. Why do you care about insurance coverage? There are a variety of reasons why any operator in the industry needs to think about insurance coverage. One, a lot of you are going to need it. If you're a distributor, the state regulations require you to get at least $2 million in aggregate coverage per year. Raise your hand if you're an insurance professional in the audience. I know there are a few. Raise your hand if you think the insurance requirements for the state make sense. It's general liability coverage, which is your typical slip and fall coverage. In this industry, products liability tends to be separated from that. And it makes a lot of sense to have distributors carry products coverage, but that's not the coverage you're being required to cover. So what else might require you to have insurance coverage? Next slide. Local insurance requirements. There are a ton of different jurisdictions, as all of you know, each with their own rules, and a lot of them are starting to employ insurance requirements, and that can take a variety of forms. Some are talking about the rating of the insurance carrier. Insurance carriers get rated on a couple of different levels, and some cities who are savvy to those types of ratings are requiring certain things of their applicants by the way of insurance coverage. Some of them, though, are actually over-requiring and requiring applicants to get coverage that's really not available on the market. We'll talk to that later. But next, local insurance requirements might be an issue. Contractual insurance requirements. If you have vendor contracts, if you have contracts with distributors that you're selling to, with retailers that you're selling to, baked into those contracts are likely to be insurance requirements requiring you to carry a certain amount of liability coverage. If you are contracting with others, it's a good idea to think about whether you want those requirements in your contracts. And that's something I'm happy to talk about offline. Again, it would be a whole separate 10 minutes. Next. But really, insurance coverage is about making your business sustainable. You want insurance coverage because things go wrong when you run a business in the long term. And insurance coverage is about spreading the hit that you're going to take when those things go wrong over the life of your business. And so I'm not going to go through these one by one, but there are basics that everyone's going to need. Again, if you're a distributor, you're going to just need general liability. Everyone's going to need workers' comp. Everyone's going to need a bond. I highly recommend anyone who is selling products in this industry get products liability coverage. It should be essential. And then you're going to want to think about other types of coverage as well. For the CEOs, COOs out there who are making decisions all the time, you have personal liability potentially. You're going to want a director's and officer's liability policy, or at least you're going to look at whether it's financially prohibitive to get that. All right, this is the comprehensive state of legality of cannabis, California good, federal bad. What does that mean in the insurance context? Obviously, there are entire days that are devoted to this topic, but let's assume it's really that simple. Next slide, please. So there are a number of different ways in which the federal illegality of cannabis can affect insurance coverage. Availability of coverage, so what products are being sold on the market, it's going to be a lot different than what products are being sold in the non-cannabis industry. It's just there are far more carriers offering liability policies, offering property policies in other industries. Because insurers are worried about federal illegality, they're worried about money laundering, and they're worried about a lack of data. Adequacy of coverage. So what are the policies that are actually getting sold going to look like? There are a number of different issues on that score, and I'll talk about those a little bit later. Enforceability, one thing to think about, there's a thing called diversity jurisdiction. Basically what it means in context is unless you are working with a California insurance company, and I believe there's one that's selling policies to or maybe two, that are selling policies to the industry, you're going to have any coverage dispute end up in federal court. Again, where cannabis is illegal, and a judge is going to have to decide whether they enforce that policy. And then it can potentially impact the interpretation. Insurance coverage tends to be written on very standardized forms, and so you'll be looking at a policy form that's been interpreted a number of times in a non-cannabis context, but how does federal illegality play in changing the way that that's going to be interpreted? Okay, so I've spoken to this. I think I don't need to go that much more, but it's a much more limited market than you would typically see. And admitted versus non-admitted, so what they're called surplus lines carriers. Admitted carriers are carriers that have vetted their policies through the state and gotten those policies approved. Their rates are approved by the state, and their policy forms are approved by the state. That's typically a good thing in most contexts where you have standardized insurance products, and they're the same for a lot of different businesses nationwide. You get price stability, the prices are likely to be lower, you know what's in the policies, and for the most part it's okay. In this industry, because of a lot of the other limiting factors, there are very few admitted carriers. There's only one admitted carrier, I believe, selling products liability and general liability policies right now, and it's actually more expensive than most of what are called the surplus lines carriers that are available, and the coverage that it provides is actually more limited. So why does it have a market? Well, brokers, and correct me if I'm wrong on this, you guys have an obligation to push out an admitted policy, or at least make it available to your clients, or say why you're not, if you have access to it. And so that they have a built-in market for that. But be careful. All right, next slide. So the adequacy of cannabis insurance. The policies that get written in this industry are far more narrow on a number of different levels than the coverage that's provided is a lot more narrow than what you'd see in comparable industries. And one example is the admitted liability policy I mentioned. How many people think if somebody gets high from product bought at your dispensary and they go and crash out there and sue you, how many people think you should be covered for that event? You're buying coverage. You're spending your dispensary. You're spending potentially upwards of $100,000. You guys don't think it should be covered? I mean, these policies have cannabis employment exclusions, and so you need to be careful as you go and read your policy and make sure you know what's in there and how that jives with your operations. If you're a dispensary, if you're really any operator and you have a cannabis impairment exclusion, you've got to know that you're taking that risk. You may be buying that policy for less money than another policy, but it's not going to cover what really is one of the more significant potential liabilities that you have. There are a variety of other exclusions I'm happy to talk about them offline, but the bottom line is there are more limited policies than normal. Why would you be denied coverage? So when you fill out an application for insurance coverage, they're going to ask you for a ton of information. And that information is going to determine what rates you're going to pay. It's going to determine what type of coverage they might provide you, whether they might provide you with a favorable endorsement that makes it a little less limited than what I've been talking about. The thing is, all of that information needs to be truthful, because if it's not, it's a basis to void your policy. And they're not going to worry about it until there's a big loss, and then they're going to use that to deny your claim. Not tendering your claim in a timely manner. Insurance in this industry tends to be written on what's called a claims-made basis, which means you have to make any claim that gets put to you by a potential plaintiff to your insurance company during the policy period, or under certain circumstances an extended reporting period. Otherwise, there is no coverage. And that can be a real problem, and it's something you need to pay a lot of attention to if you're going to switch carriers, because the amount of coverage you have and for what can change a lot, and you can wipe away years of potential coverage if you don't switch over in the right way. Specific claim isn't covered because it's limited. That's a basis. But what about federal illegality of cannabis? Is that going to be a basis for denying your claim? And there's a long arc of cases on this. I just started with the last one. It looks like the answer is going to be no. There was a case out of Colorado in 2016 in which a carrier knowingly issued a policy to a grow operation. There was a fire, not even on the site, but soot and smoke went through the ventilation system, and it destroyed the ventilation system and it killed all the crops. Carrier came in and said, Your Honor, can we even cover this? It's cannabis. And the court said, you knew full well what you were getting yourself into. I'm not going to let you out of your policy simply because it's federally illegal. We're going to hold you to this. And it's different than what the court had done in those other cases I mentioned, where it wasn't a policy that was expressly purchased to cover cannabis risk. In those situations, the courts have said public policy, even if these policies as interpreted would cover cannabis as a public policy matter because it's federally illegal, even if it's legal under state law, you're not going to be covered. So what does that mean? And this is, in California, as a lot of you guys know, AB 1159, basically commercial cannabis operations are going to be a lawful purpose of contract, and so a carrier is not going to have that argument in California, which to me suggests there's an even better argument under California law for enforcing cannabis policy. And then, just to really draw into stark contrast, there are insurance brokers out there who are still selling cannabis companies policies that are not written for cannabis operations. It's not happening nearly as much as it used to, but these policies, even if there's some argument that maybe they meet the insurance requirements because the insurance requirements don't say anything about having to be cannabis-specific insurance, they will not cover any claim related to your cannabis business operation if the carrier does not know that you're a cannabis company and willingly issue a policy. So interpretation of cannabis policies, how is federal law going to change that? Well, this is a form taken from a policy that's written in this industry. And it's a form that's going to add people as additional insureds, which again is one of those things you're going to have to do pursuant to contractual insurance requirements. And here you've got a provision that says, but this is only going to apply to the extent permitted by law. What does that mean in the context where cannabis is legal under state law, but illegal under federal law? It's a question that hasn't been answered, but it's a fair one. Another one, and this provision came into play in the case in Colorado. Contraband is typically excluded from property policies. What does that mean in the cannabis context? Well, in the Colorado case, the court said, in the Colorado case, the court said, again, where you knowingly issue a policy to a grow operation, you know you're dealing with a cannabis company, I'm not going to interpret terms like contraband to mean cannabis when you're talking about exclusionary definitions. It's not a fair definition under the policy. It's at best vague, and when insurance provisions are vague, tie goes in favor of the person who's buying the policy. However, there is also an exclusion for growing crops. Here, the court said, insured, you've got to read your policy. If you're trying to cover a grow operation, and you want your plants covered under a property policy, you can't buy a policy that excludes growing crops. And it's right there in the contracts. You got to live with it. And so the end result at the end of the day is the ventilation system is paid for by the insurance. The crops are not. There was another case actually that there were a couple lawyers in the office from McAllister Garfield, and they tried this case. And I've actually given Sean a lot of credit because I think they were able to successfully settle it. But there was a case where a gentleman ate a candy bar and ended up shooting his wife, and the kids sued, I believe, was it the retailer or the manufacturer? I can't recall. I think it was the retailer. Retailer, yeah. Okay. And with the product's liability claim, and in the policy, there was a provision that said you don't get coverage for psychotropic substances. You're selling cannabis. You know, this is a psychotropic substance, but the carrier came back and it survived a demur, I believe, on the basis that that this provision was in there, and so it never ultimately got settled as to what that means and whether cannabis is included in psychotropic substances. But I think it's a closer question than contraband. Another one, interpretation of policies. You've got a carcinogens exclusion in a lot of policies that are out there. Cannabis smoke is a recognized carcinogen under California law. So if you have a carcinogens exclusion and it's broadly worded, potentially anything that's related to flower, anything that's related to vaping, all excluded under that policy. The good news is, if you read your policies, if you pay attention to what your business operations are, and you try to negotiate for the terms that you need, and pay attention and really scrutinize what's on the market, it could really work for you. Recently, there was a $1 million payout to a grower who lost their crops in the fire, and the only reason they got coverage was because they had their broker lobby for a provision that sadly you can no longer get in the state because the carriers turned and run, but that it protected what's called atmospheric condition changes. And provided coverage for them. Because of that, not only these guys, but a total of $8 million in claims were paid out, which is a big data point for the industry, because one of the questions is, are these guys going to pay you, right? Are they going to try to deny claims? And this carrier at least stood by their policy, and others have as well. And I think that the more attention that's paid, the more that's going to be restored as trade. So I'm happy to answer any questions now or on an individual basis.
Do you think these health hazard exclusions and impairment exclusions are, there's a psychoactive parts of this plant? Do you think when it comes down to a court decision, do you think they're going to be pulled up in court based upon the law, the court rulings that you've seen so far?
I think there are good arguments that. I think there are good arguments to be made on both sides. I think that I don't think that a lot of operators understand that these exclusions exist in the policies, and I don't think that there have been a lot of big claims at this point, especially in the liability context.
Yeah.
I mean, until January 1st, it wouldn't have occurred to a lot of people to sue the dispensary. But at this point, plaintiffs' lawyers are, like everyone else, watching all the news reports and seeing all the big dollar signs. And they're going to be coming after folks. There are going to be products liability claims. There are going to be ADA violation claims. That's something that wasn't talked about today, but there's an entire cottage industry of law that's just devoted to going to places of public accommodation, and so that's every retailer out there, and checking to see whether you've striped your parking lot properly, whether you have the proper handicaps, whether the signs are the right number of inches from the ground to the ceiling. And I mean, they're coming, and you want to be covered well. And so you've got to take this stuff seriously, and it really is worth it. It's not the same as the 20-year jail sentence that's hanging over everyone's heads, but from a practical standpoint, it's much more likely to sink your business, and if you have an uncovered claim. And so, thank you all for eating your vegetables. I don't see anyone sleeping.
Great. Thank you.